5 minutes for rebuttal.
Thank you.
I'd like to focus on the issues of class membership and the comparative fault apportionment. First, with regard to class membership, it's undisputed that Mrs. Schlenther didn't know that she had COPD until July of 2001. So the dispositive question before you is whether she should have known that she had COPD almost 5 years earlier on November 21st, 1996, which is the class cutoff date in Engel.
The issue is whether there's competent substantial evidence for which a jury should have made it.
Correct. And the answer to that question is no as a matter of law. We know that both from Castleman and Frazier, which stand for the proposition that symptoms like shortness of breath do not create a fact question on whether a smoker knew or should have known that the smoker had an actionable disease like COPD. Castleman is a case in which the smoker had symptoms, had shortness of breath, had a persistent cough, and had chest pain. And the court said, as a matter of law, that's not sufficient to create a fact question on whether the smoker should have known that the smoker had a disease, and affirmed a summary judgment for the defendant.
COPD seems to me to be a disease, something like asbestosis or a number of other things that develop progressively.
Right.
And so it's not like you can say, well, this is the day he has chicken pox.
Right.
And so, what is it that a plaintiff needs to understand? If I'm feeling a cough and I think I shouldn't be smoking because I'm coughing, is that enough for COPD?
No, and
why not?
that's what both Castleman in the class membership context and Frazier in the statute of limitations context, because number one, those cases say the smoker can't sue for the symptom, for the cough or the shortness of breath and so on. And number two, we don't expect lay patients to be able to assess the medical significance of shortness of breath. We don't expect them to be able to figure out, is this indicative of an underlying disease like COPD, which would, of course, support a claim against a cigarette manufacturer, or is it just shortness of breath, which would...
Should she have known she had is not the same as diagnosis, right?
Correct. Correct. But the difference, and that could be a critical difference, for instance, in a case where the patient ignores the advice of the doctors, right? There's no ostrich principle in which the plaintiff can prevent himself or herself from learning about the disease by not following advice of the doctors. But here, we have a smoker who was seeing doctors, and the doctors didn't figure this out. The doctors didn't figure this out until 2001. And what Frazier says most emphatically is, we don't assess the symptoms with the benefit of hindsight. We don't say, now that the doctors in 2001 and 2002 figured out that the shortness of breath in 1996 really was more than just a symptom, it was indicative of the underlying disease. We don't look at the symptom with the benefit of hindsight and say, oh well, therefore she had COPD and therefore she should have known. Frazier says that's the wrong question. The question is, ex ante, when she has the symptom, should she have known? And here, with regard to the doctors, there are two relevant interactions in the record. There's a 1995 interaction between the smoker and the doctor, in which the smoker presents with all sorts of symptoms. The doctor assesses it and says, get a heart test, get a stress echocardiograph. Doesn't say, gee, this could be COPD, you better go get a lung function test. Says, get a heart test. That's the evidence of what the smoker was told and knew at the time. Fast forward to 1998, right? 1998 is 2 years after the class cutoff date, and it's undisputed that COPD is, as you say, a creeping disease. The symptoms get steadily and progressively worse over time. So to the extent she had COPD-related symptoms, we know they would have been at least as bad, if not worse, in 98 than they were in 96 at the class cutoff date. She goes to the doctor in 1998, and what does the doctor observe? If you look at only one piece of record evidence on this issue, please look at trial transcript pages 1006 to 1007. Testimony from the smoker's treating doctor about the 1998 visit, in which the doctor says, no respiratory distress. The doctor says minimal coughing, and the doctor says lungs are clear except for something called minimal crankles, and then 6 pages later at 1013 the doctor says lungs are clear. So you have the smoker presenting 2 years after the class cutoff date. She's seeking treatment, she's going to the doctor, and the doctor finds minimal symptoms, and it takes the doctor 3 more years until the doctor even orders the pulmonary function test that revealed the COPD.
And does that treating physician provide us with any expert opinion on the Engel threshold question?
I'm sorry, on the class membership, there were 2 doctors who testified for the plaintiffs. The treating doctor, the primary care doctor who saw the patient in 1998 in that interaction that I just described.
Which one was that?
That was Dr. Worth.
Worth, okay.
And then, so Worth sees the patient. What we see are the symptoms I just described, which bring the case directly within Castleman and Frazier on the legal proposition that symptoms like shortness of breath don't create a fact question on what the smoker should have known. And then Worth in 98 records those symptoms, doesn't do any follow-up to figure out whether she has serious lung disease. Takes him 3 more years. In 2001, he says, gee, maybe I better do a pulmonary function test, and refers her to the second doctor who testified, Wim Squires, the pulmonologist who first saw the patient in 01 and then started treating the patient once the COPD was established. So in order to find a fact question, you would have to either treat what Frazier called medically and practically ambiguous symptoms like shortness of breath as sufficient in and of themselves, or you would have to conclude that somehow Mrs. Schlenther should have outguessed her own doctors in figuring out that the shortness of breath was really indicative of an actionable underlying disease. And Frazier says, quite rightly, that the court should not engage in that sort of belated armchair analysis, not only using the benefit of hindsight, but holding the smoker to a standard of a medical professional.
The smoker also doesn't have to get an official or formal diagnosis of COPD.
Doesn't have to get a formal diagnosis, but in the context...
Wasn't there some concern expressed in, I think it was 95 or 94, that it was recommended she get a pulmonology exam and testing done?
There's disputed evidence on whether or not she had the test. For purposes of my argument, I'm going to assume, of course, that she did, because I'm taking all reasonable inferences against me.
The question becomes, at that time, were there not symptoms that supported a recommendation that she get the testing done?
Oh, maybe so in 94, but we don't know.
We don't know what she did.
We don't know what she did.
But there apparently were some symptoms sufficient to support a recommendation that she get tested.
And maybe that supports at least the inference that she should have pursued this issue. And if the evidence were...
Her failure to pursue the issue dispositive?
It's not the facts. It may be if she hadn't pursued it, then she might have an argument that there's a jury question on should have known, as you suggest. She has the 94 recommendation. She doesn't follow up at all. That's sort of an ostrich case. You could say she didn't know, but maybe she should have known. At least it's a jury question. The reason why this isn't that case is we know that she did continue to pursue this issue with her doctors. We don't know the results of that test. We do know that she went back to a doctor in 95, disclosed all the pulmonary symptoms. The doctor in 95 records the symptoms as exertional dyspnea and decreased...
Let me ask the question this way. If the doctor failed to correctly diagnose, does your client get the benefit of that?
In the context, the answer is yes. In the context of class membership, that works to the benefit of my client. In the context of statute of limitations, if we were having the same debate,
so then
it would work against my client.
So then you're not acknowledging that manifestation is controlling as opposed to diagnosis?
No. Manifestation is controlling. We're saying the test for manifestation incorporates a requirement of knowledge of the elements of the claim. And that's what the first DCA held in Castleman.
She had a really bad doctor who failed to correctly diagnose it. That works to her disadvantage. Her
disadvantage in the context of class membership, it works to her benefit, to the benefit of plaintiffs in the context of statute of limitations. We were on the other side of this issue in Frazier and in limitations cases, right, where we want the smoker to know sooner rather than later. And the courts have told us very emphatically that if the only thing the smoker presents with is the shortness of breath, and if the smoker goes to the doctor and the doctor doesn't figure it out, the smoker won't be, there's no fact question on whether the smoker should have known. So the key distinction between the case you posit, she gets a piece of information in 1994 and she never follows up, and then the jury could find, well, she should have known. If she had followed up, they might have figured this out. The reason why that isn't this case is she is pursuing this issue in 1995. She's presenting to a doctor, and the doctor's reaction is, you may have a heart issue. Nothing about you may have a lung issue. You had this test. I don't know the results. You better redo it. Doctor says you may have a heart issue.
Mr. Francis, if we agree with you on this, what is the relief that you're entitled to?
We would get judgment on the ground that the plaintiff failed to prove class membership.
Now, just the fact that she's not a class member doesn't mean she can't sue Reynolds for her condition.
She could have, but this case would be time barred because without the benefit of Engel tolling, the case would be time barred.
Because so the complaint is exclusively dependent upon Engel and not on other theories?
Complaint was filed in the 07-08 time frame. The death was in 2001.
Okay.
So if you put Engel to the side, the wrongful death claim would be time barred.
And I'll buy my own time here, but I'm kind of curious as to how the Engel transition and post-Engel is going to play out. Are we actually going to have some cases that are tried on either they are an Engel or not an Engel?
Occasionally that comes up, but it would have to come up in the context of a case where the complaint would be time barred even without the Engel tolling rule. And there's a case called Hargroves in which that actually happened, and the plaintiff lost on Engel class membership issues and then just pursued an ordinary civil claim without the benefit of the findings. Right. But Mr. Schlenther can't do that here because if she was not in the class, his claim is time barred.
Time barred. Okay. So if somebody starts manifest the disease today, my impression is that they get the benefit of what I'll call the collateral estoppel factors from Engel, but not the class factors. Is that?
If they manifest today, they wouldn't be class members.
And they don't get any benefit at all.
They wouldn't.
Your standard jury instruction you're using now has this half a dozen things that they get one way or the other, and then three or four.
The two big benefits of being in the Engel class, one is you get the tolling rule.
Right.
So someone in the 07, early 08 time frame who's in the class or whose decedent was in the class can sue for a much earlier death. And the other benefit is use of the Engel findings, but if someone were not in the Engel class, of course, in Florida there's a mutuality requirement, so that plaintiff couldn't invoke the collateral estoppel effect. I'm probably on my own time now.
And this, if we need a couple extra minutes, we'll deal with that, but
I do want to say a few words about offsetting, because
Right.
that's an issue that arises in virtually every progeny case. It's important to us not only in this case, but in all Engel cases. The easiest way to resolve the offsetting issue is to follow the first DCA decision in Hyatt and conclude that Mr. Schlenther forfeited the ability to argue against a comparative fault offset by affirmatively inviting the offset in the trial court below.
when was the first time that the plaintiffs raised this issue in the trial court?
This came up in the context of jury instructions, and this goes to the waiver point, because the most obvious waiver and the most extraordinary fact about the case is when this issue came up in the context of jury instructions, both sides asked for and received the instruction.
So kind of going back to my question then, the plaintiffs didn't request special instructions on this subject. So when is the first time the plaintiffs put anybody on notice in the trial court that this was an issue they wanted to make?
The plaintiffs try to hinge everything on their complaint, and they say, well, the complaint put Reynolds on notice that we were going to argue against offsetting. That's true, and that simply establishes that the complaint wasn't the basis for the waiver. But of course, the plaintiff can change positions and waive through later acts, and here the plaintiff did that by affirmatively seeking jury instructions and a verdict form that were inconsistent with what the plaintiff said he was going to do in the complaint. And there's no ambiguity on this point. The jury instructions that the plaintiff sought said the court will reduce for comparative fault, period, full stop, no qualification for claims. The verdict form asked the jury to make a single offsetting decision and required the jury to do that if it found for the plaintiff on any single claim, including the concealment and conspiracy claims. That's the verdict form that the plaintiff proposed. We did too.
Did any party ask for a more interrogatory type verdict form to break it down by cause of action?
I'm sorry?
Did any party request an interrogatory verdict form breaking it down by cause of action?
On the offsetting question, only in what the parties requested and received on the verdict form. The verdict form is structured as follows. There's a question, I think it's 3 through 6, but don't hold me to the exact number. There's a question that is the trigger for liability under strict liability. Then there's a trigger question for liability on negligence, one on concealment, one on conspiracy. And then the verdict form says, if you find for the plaintiff on any one of the above, then go ahead and answer the comparative fault question. So imagine the jury following instructions in a case where they check yes on conspiracy. They are required by the instruction in the verdict form to answer the apportionment question. And then all of that, the jury instruction and the verdict form features that I just described, are reinforced by the plaintiff's closing argument. It's at 2501 to 03 of the trial transcript, where the plaintiff argues, here's the argument in a nutshell. We accept comparative responsibility. They don't. Give us credit because we're being more candid with you than the other side. And then when you make your offsetting, your apportionment decision, you should assign the lion's share of the fault to Reynolds because you're comparing the slight negligence of Mrs. Schlenther to, in counsel's words, the 50-year conspiracy.
But the jury didn't buy that.
Well, the jury made its apportionment decision.
They didn't make the lion's share of the liability that of your client.
No, but they're making an apportionment decision in the face of an instruction that tells the jury the court will reduce.
But what's interesting to me about this is the jury comes back with an amount of damages. Mm-hmm. That amount really should not change, whether it's comparative or not. They're supposed to come up with the amount they conclude is the damage amount.
Fair enough.
And then they conclude who's responsible for what percentage of the negligence or what percentage of liability. And then the judge, in theory, says, okay, well, for those things that are comparative negligence applies, I would have to make a reduction. If comparative doesn't apply, there's no reduction. So I'm trying to get a handle on the harm to your client. I mean, the jury may have been misled to a degree, but ultimately they come up with a number of damages, they come up with a percentage, and then it's left to the judge to do whatever the judge is supposed to do as a matter of law.
There are three different sources of prejudice. Let me try to unpack it for you. The first is that even though the jury is supposed to make the determinations independently, it's by no means clear that juries will, and as the fifth DCA explained in the four-line case, the jury may inflate the damages. We don't know for sure, but they may inflate the damages if they are told that the damages will be reduced. And that in and of itself was sufficient to compel a new trial in four-line.
Well, let me interrupt for a second. Let's say a better instruction was given to the jury as to how this would all work. Shouldn't the amount of damages as to each cause of action have been the same?
The amount of damages doesn't vary by cause of action.
The jury is not supposed to make any modification to the amount of damages that exist. That's left to the discretion or to the legal requirements for the court.
Based on the comparative fault finding?
Right.
Yeah, the damages, yes. Those are, but
what you're, in some ways it seems like you're speculating. The jury might have done this, the jury might have done that, but ultimately the jury had to come up with, whether a good instruction or a bad instruction, an amount of damage and an amount of comparative negligence. And what the court, it seems what the court should have told the jury is, some of these causes of action I might have to tinker with post-verdict, but look, you come up with an amount of damages and you come up with a comparative negligence.
What you're suggesting is that the jury shouldn't be instructed one way or the other about the legal consequences of its apportionment decision on damages. I don't think that's right, because the standard instructions say that in a case, if it's a case where you're supposed to apportion, you instruct the jury. The standard instruction says the jury, the damages verdict will be reduced. So number one, the standard instruction itself establishes that the jury should be instructed on this. But even if I'm wrong about that, the most your line of reasoning suggests is that maybe there's an argument the jury shouldn't be instructed one way or the other. Maybe the jury should just be told, do your job and the court will make whatever adjustment is legally appropriate. That isn't this case. In this case, the jury was affirmatively misled, and that's enough to compel a new trial under the reasoning of Foreline and under the reasoning of Hyatt. And this is even one step beyond.
But had the jury found no intentional tort, there'd be no problem with the instruction, because the court would have made an adjustment.
On our view of the merits, there's no problem with the instruction either way. I mean, if the jury had found no intentional tort,
Legally, the instruction seems to be wrong in this case, because there would not be an adjustment for an intentional tort. I know
there's a dispute on that, and if you want me
I
to
understand the arguments.
if you want me to talk about the merits, I will. But I think the waiver rationale is much cleaner and easier for us. So I think our position is that the instruction was correct either way, but that doesn't really matter for purposes of waiver. The waiver argument is simple. Look at what the first DCA said in Hyatt. What the court can't do...
Mr. Katsas, Judge Silverman and I are a deadly combination. He always gets excited about cases about the 18th minute, and I'm a lackadaisical timekeeper. But we have reached the 26th minute.
You've been very generous.
15 minutes, so I think we probably ought to give the other side some time to talk now.
You've been very generous. Thank you.
Thank you.
Judge Altenburn and I have been on the court together too long.
Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Brannick & Humphreys, here representing the Appellate, Mr. Schlenther. So let me focus on the two arguments that Mr. Katsas raised, first starting with the
Before you get started, Mr. Brannick, let me comment to you that I know you enjoy putting an introduction in your brief that isn't quite in the rules, but it works okay when it's about 20 lines long. But you actually skipped your statement of the case and the facts and have really what is essentially a 9-page legal introduction to your brief. And I at least found that not to be as useful as if you had given me a statement of the case and the facts. So I just wanted you to know that. Okay.
Well, I'll have to go back and look at the brief. What I suspect happened is that somehow the subject heading statement of the case and facts just inadvertently got dropped.
Well, there really isn't a statement of the case and facts here. There's a legal discussion for 9 pages that disguises itself as a statement of the case and the facts. And that's just, I think, over the line myself. But
Well, your comments are noted, Your Honor, and I apologize for that. But certainly that discussion focused very clearly with lots of record sites on exactly what the evidence is on manifestation. So let me start with the class membership problem. First, I just want to note, although I think it's academic in this case, that Mr. Katsas is conflating the standards of accrual for statute of limitations purposes with the definition of class membership. And Judge Gross does a very excellent job in a Ciccone case of describing exactly why that's wrong. Now, we don't need to wade into that controversy here because Reynolds got the benefit of the stiffer instruction where we had to prove that she knew or should have known, and we satisfied that, and there's competent substantial evidence to support that. So we have to do two things, and there has to be competent substantial evidence to support two things. One, that she was in fact symptomatic prior to the class cutoff date of November 21st, 1996. And then secondly, that she knew or should have known. In terms of being symptomatic, Wim Squires, a pulmonologist, says that she was symptomatic in 1994, 1995, based on the symptoms that she saw when she treated her, and working backwards from there, understanding that COPD is a creeping disease that progresses slowly. So Dr. Wim Squires suggests that she's symptomatic in 1994 and 95.
now, does she testify that this patient or an ordinary reasonable patient should have known that they had COPD because of these symptoms?
In terms of the should have known, no, she did not. The should have known requirement of the test comes out of the notes from Dr. Walsh. Dr. Worth, of course, another one of the treating physicians, was a partner of Dr. Walsh. Dr. Worth first says that based on his review of her file and his treatment of Mrs. Schlenther, that she definitely was symptomatic in 1994 and 95. So both treaters agree on that. So now the question is, how should she have known? Well, Dr. Worth notes her visit with Dr. Walsh. That visit took place in 1995. Dr. Walsh specifically says that she's got symptoms of COPD, that she's got shortness of breath and she has decreased tolerance for exercise. But then the important thing is he goes on to note that she's a smoker and that they had a discussion about her smoking and that she needed, and that she assured him that she was going to stop smoking. Now, what that discussion shows, particularly when you couple that with the testimony about what Dr. Walsh's bedside manner was that they had an extensive discussion about her symptoms, including her symptoms relating to COPD, the shortness of breath, and the decreased exercise tolerance, and that as a result of that, he told her that your smoking is causing these problems, and you need to stop smoking. That's a very fair inference to raise to draw.
Was there any reference in the notes actually to COPD?
No, just to the shortness of breath and to the...
But that's also consistent, including the recommendation to stop smoking for someone who suffers from asthma.
It certainly could be, and that was a fair argument for them to make to the jury. And the jury could draw either inference. They could draw the inference that she should have known that she had COPD as well as asthma, or they could have drawn the inference that she only had asthma. But that was a factual question for the jury. The point is that she was clearly symptomatic prior to November 21st, 1996. Both treating physicians testified to that. We also remember there's a discussion about that 1994 pulmonary test. Now, Mr. Katsas has recognized that there's a factual dispute in the record about whether that test took place, but for the purposes of where we are today, we have to assume that there was a pulmonary function test taken in 1994. And the evidence was that if that test was taken, it was because a doctor suspected COPD. Now, I think the fairest inference to draw from all those facts is that Dr. Walsh, in fact, ordered that pulmonary test, and it wasn't 1994, it probably was in 1995, and Mrs. Schlenther just misremembered about what date that it took place. But when you couple the fact that there's evidence in the record of this pulmonary test in 1994 with the evidence of her discussion that had to have taken place with Dr. Walsh, and you couple that with the evidence of the treating physicians testifying that she was in fact symptomatic in 1994 and 1995, there was clearly competent, substantial evidence in this record to support the jury's verdict that not only was she symptomatic, but that she knew or should have known. But if there's any doubt about that at all, I would encourage this court to adopt the reasoning of Judge Gross in the Ciccone case, which is that we don't look at the know or should have known test in the statute of limitations context for the purpose of determining class membership. What we do in class membership is we look to the Supreme Court's definition of the class, and that definition was that anyone who's a member of the class is someone who has suffered, was suffering, has suffered, or died from the disease prior to the class cutoff date. Clearly, all the Supreme Court required was that the plaintiff be symptomatic. There's nothing in the Engel decision where the court is describing the class that suggests that there has to be, in addition to being symptomatic, this known or should have known. And that would be completely contrary to the Supreme Court's analysis of the class definition, where it was trying to, as it discussed, inject certainty into who's a class member and who's not. And if you make it class member dependent upon a subjective test like knew or should have known, you're not going to have any certainty in the class membership test at all. So we would strongly recommend that this court adopt Judge Gross's reasoning from Ciccone. Now, we don't need to go there. We think there's competent, substantial evidence in the record, and so we would.
Ciccone's pending in the Supreme Court. That issue, is that right? Is the conflict between Ciccone and the First District pending in the Florida Supreme Court?
No, I don't believe that is. I think there are other conflicts that are. It is? Oh, it is. I'm sorry.
The majority rule is it
okay.
is. Okay.
Then I just want to spend a couple of minutes on the comparative fault. And
actually, I'd sort of like to have you spend a little bit on the tolling issue on conspiracy, if you.
Oh, sure.
He has not argued that, but I'm interested in what. Because the date was used for fraud, but not for conspiracy in the jury instructions and the like, and I just find that a little mentally confusing. So.
Well, I agree, and our view of the law is that the date of reliance is absolutely irrelevant either to the fraudulent concealment claim or the conspiracy claim, and that's what I strongly argued to Judge Boyer when we were doing jury instructions. Judge Boyer, however, wasn't convinced. He had the Hess case that had come out at that point in time, which suggested there was a distinction between the conspiracy side and the fraudulent concealment side, and he adopted. At first, he was going to require proof of reliance for both the conspiracy claim and the fraudulent concealment claim. We pointed out the very strong language from this court in the Latchkey case, which says that for purposes of the statute of repose, it's not a matter of accrual, it's a matter of focusing simply on the conduct of the defendant, and that in a conspiracy case, the statute of repose runs from the last act in support of the conspiracy.
This conspiracy, I confess that I'm not sure I completely understand the conspiracy theories that are being tried in these tobacco cases, but it feels like what I'll call industry-wide fraud. Is that what this theory is?
Essentially, that the tobacco defendants, the Engel tobacco defendants, agreed with each other that they would conceal both the deadly nature of tobacco smoking as well as the addictive nature of tobacco smoking, and that for a period of 50 years they linked arms and first denied that there was any evidence that tobacco smoking was deadly or addictive. Then, when the evidence started to come out that it was, poo-pooed the evidence and suggested that it hadn't been scientifically proven, until finally we get to the year 2000 when they admit that tobacco smoking is not only deadly but addictive.
And I guess what's confusing to me is that on the straight fraud theory against one tobacco company, apparently the way we're doing this right now, there is a 12-year threshold that goes back to 82 from the 96 Engel period.
Right.
And yet, if the fraudulent statement was made not by this defendant but by someone else in the industry, it goes back indefinitely for a conspiracy to misrepresent, and that just doesn't satisfy my sense of logic, I guess.
Well, I think it stems back to what the Supreme Court told us in the Cush case, which is that statute of repose is different from a statute of limitations. The way they're looking at statute of repose, it just becomes a second statute of limitations.
The repose that's being used in the fraud cases to establish the 82 time period?
Right, 12 years before the Engel case was brought, brings us back to that 1982 time period. So there has to be some.
Unless the repose is from the end of the conspiracy, which is one line of cases, it would be treated the same as the fraud case.
The dispute between the two sides is everyone agrees that you have to show conduct after 1982. That's easy to show because they were denying that smoking was deadly and addictive all the way up to 2000. So there's no dispute about that.
In this court, we must do that time period.
So but the tobacco folks want to add a second requirement, which is that you also have to show that after 1982, that your particular plaintiff relied upon one of those misstatements. That's what's wrong, and the Frazier case has rejected that specifically. The Hess case, one of the cases they rely on, rejected it as to fraudulent concealment, and the Webb case in the first DCA has rejected that. And the reason they reject it is because the Florida Supreme Court has told us that there's a difference between a statute of repose and a statute of limitations. And this court has agreed with that in both the Latchkey case and the recent Hallgren case, where you've stated that we're not looking at the accrual of a cause of action when we're looking at repose. A repose runs from the conduct of the defendant. Essentially what the statute of repose is the get out of jail free card for the defendant. If enough time has passed since you stopped doing wrong, then we're going to weighing the policy of protecting plaintiffs against the policy of long stale claims. We're going to give you basically a get out of jail free card after 12 years. But that card, you can only use that get out of free card if you've stopped doing wrong. So as long as the wrong continues, so as long as the misconduct continues, that 12 years never starts to run. Because that misconduct continued all the way up to the year 2000, statute of repose really shouldn't be an issue in these cases.
But there is an issue of reliance in both of the fraud theory and the conspiracy theory.
Right, and for the purposes of winning the case.
Conspiracy, this woman could rely on something she heard in 55 when she was 13 and started to smoke, but for fraud, it has to be after 1982, is the way the law is laying out right now. Is that fair?
It is fair to say that to win on fraud, you've got to prove reliance. We think it doesn't matter when you have to prove that reliance, and the Frazier case out of the 3rd DCA and the Webb case out of the 1st DCA agree with that, and the 4th DCA takes the contrary view in the Caton case, the Bonamo case, and Halfway in the Hess case, and that issue is in front of the Florida Supreme Court right now, and I'm confident the Florida Supreme Court is going to resolve that issue, consistent with the way it decided Cush, and say that we don't need to look at reliance for repose purposes. That's part of the accrual of the cause of action, and that's going to be important for statute of limitations purposes. But again, in repose, we don't look at accrual. We look at the defendant's misconduct, and so long as the defendant's misconduct continued, which it did, past the repose period, that's all that's relevant. So we think those cases are the better reason cases. That's the view that this court has adopted in the Latchkey case and recently reaffirmed in the Holmgren case, and we think that that's how this court could rule as well.
Now, if you want to go on to comparative, I'll let you do that.
All right. On the comparative fault, I think we're clearly right on the law, and all of the cases to address that point so far, the Hyatt case and the Surrey case out of the 1st DCA agree that we're right on the law. So the only question here is there a waiver?
And candidly, that's bothering me a little bit, because you didn't request any special jury instructions, and even on the verdict form, we have that standard language that informs the jury that your collective decision, however you make it, is going to be reduced by the percentage that you attribute to the deceased person. And
well,
I mean, if you didn't want that, why did you tell the jury that?
Well, and my answer to that is, if they didn't want that, why didn't they tell the jury?
Well, it's to their benefit. The last time I knew, you have to object to things that are to your detriment.
But recall, though, in this case, that our complaint specifically said that we're conceding some fault on behalf of Mr. Slenther, but we are not going to be asking for...
jury instructions and closing argument, you tried the whole case without ever telling the jury that this was in your complaint and that this was how you were going to do it after they were discharged. Isn't that a problem?
I don't think it is, and the Supreme Court has told us in the Hill case that it's not, and here's why.
Hill has the same problem, a verdict form that tells them specifically it's going to be reduced and then it's not?
The instruction that was given to the jury in this case is the standard jury instruction on comparative fault. I agree.
Apparently is inadequate under your theory when you have an intentional tort and a negligence type tort.
I would agree that it would be better to draft the instruction with more clarity so that that issue is out of the case. But I don't think it's reversible error for precisely the reason that Judge Silberman was articulating in his questions to Mr. Katz's, which is the purpose of the standard jury instruction is to tell the jury, don't worry about reductions of the damages based on your decision on comparative fault. What we want you to do is come up with a total damage award, and then the judge is going to take care of everything.
But that's not what the standard instruction says. And so the jury, when they are trying to reach a collective decision, as 6 people probably compromising on some issues with one another, knows that whatever the number is they write on one line is going to be reduced by the percentage on another line. And we have 6 people coming to this decision rather than 1. So it can be a little bit of a sausage-making process back there, probably.
There's no doubt about that, but one thing that is absolutely clear in the law is that we assume that the jury follows the court's instructions. And if we assume that the jury follows the court's instructions, we are going to assume that the jury comes up with the actual number of damages.
And does the jury have the right to assume the judge will follow what he's told them he's going to do?
That's really, frankly, that's none of the jury's business at all. The purpose, again, is of that standard instruction is to inform the jury that the judge is going to take care of those reductions for you. Your job, ladies and gentlemen of the jury, is to come up with a total damages number. The legal impact of that number and other factors such as insurance, collateral sources, and the reduction for comparative fault, that's not for the jury, that's for the judge. So the question is...
If we were to affirm in your favor, will we have to conflict with Hyatt, or however you pronounce the First District waiver case?
I don't think that you would have to, because there are factual distinctions between this case and the Hyatt case. The Hyatt case, the court noted specifically that in the complaint, the plaintiff had not reserved and made clear that they were not going to be seeking apportionment in connection with the intentional tort claims. And you'll notice in the Hyatt case, that's a big factor that the court relied on in its determination of waiver. So there were really two things going on in Hyatt. One was the complaint, unlike the complaint in our case, didn't state that there was not going to be apportionment in connection with the intentional tort. So that was the first one. The second one was that the Hyatt court said that this was a strong feature of that case from start to finish. That's not our case at all. There were a couple of mentions in this case that she accepted responsibility, but this jury there was never any hint from the lawyers in this case that was going to impact what they were asking for in damages in connection with the intentional tort.
In the closing arguments, nobody went through the verdict form with the jury and told them how it was going to function as to comparative? I haven't read that part of the closing argument.
There's certainly, I don't recall exactly the discussion, but I do know that there was no suggestion by anyone that the jury's finding of intentional tort was going to result in any sort of reduction of the awards. The lawyers never said that. The only basis for waiver is the use of that standard jury instruction. And so this case comes down to whether we can assume that was reversible error. And we think the answer is no, because that would have to assume, as Judge Silberman was articulating, that the jury is going to violate its and not follow. It's going to violate its duty and not follow the court's instructions. If we assume that the jury follows the court's instructions, then there is absolutely no error, absolutely no prejudice to Reynolds here. And
you don't think the jury, back when they're deliberating, does the math themselves and figures out that the judgment is going to be 50% of this number? I mean, most lawyers, by the way, tell them this in closing argument and go through the math with them as well. I don't know that happened here, but...
Right. I mean, obviously, the problem we have here is that if there had been a verdict only on the non-intentional tort counts, then you have to have those instructions for the jury. And I agree, as I've conceded before, that it would have been better to have a more specific instruction. But I don't think that you can put all of the blame for that lack of the specific instruction on the plaintiff.
Was the judge reminded of this at least during the jury instruction conference? Judge, you need to know that we didn't ask to strike their comparative negligence defense as to certain counts, but when this is all over, if we win, that percentage is not going to count. You understand that, Judge? Did anybody do that?
There was no specific discussion about that during the jury, at least not at the jury instruction conference, no. It first was raised back in the post-trial, but it was a feature of this case from the very beginning.
But basically, you had the judge misrepresenting the law to the jury without pointing that out to him. Or her, I'm not sure. It's Judge Boyer.
Judge Boyer did. Again, it would have been better if the instruction had been more clear. But I think Reynolds bears the same responsibility for that lack of clarity as the plaintiff does. It was clear from the very beginning of the case that we were not going to be conceding any apportionment of fault in connection with an intentional tort claim. So Reynolds knew that.
And knowing that, complaint, and then I haven't read their comparative negligence defense, but I bet it doesn't say as to counts 1, 3, and 4, but not as to count 5. We're raising comparative negligence. Does it?
No.
Did anybody move to strike their comparative negligence defense or limit it as to certain counts?
No. I mean, the issue was really not joined until post-trial.
You know, these cases get massively pre-trial. Is there anything in the pre-trial order or that discussion where this issue is addressed at all?
Not that I recall.
Why isn't that waiver?
If it is, it's as much of a waiver on the Reynolds as it is on the plaintiff. If Reynolds knows, based on the complaint, and it's exactly what the first DC8 held in the Surrey case, the case that came out prior to Hyatt, that's in the complaint. That's an argument that's made in the complaint. And what Surrey says, that makes that a feature of the case all the way through the post-trial, which means that when this was argued in front of the jury, Reynolds, knowing that we were going to be arguing post-trial not to reduce that verdict, if it thought that the standard instruction didn't fit, it had a duty to suggest that that standard instruction is inaccurate in this case. So I think that it's unfair to suggest that all of the waiver problem falls upon the plaintiff. I think it equally falls on the defendant. But the more important argument is the argument articulated before, which is that for them to win this argument, they have to convince Your Honors that the jury was going to violate its duty and ignore the court's instructions. So long as we assume that the jury followed the instructions and came up with the amount of the damages that were appropriate in this case, then there is no harm to Reynolds, and that's how this case should be decided. So if there are no further questions, for all the foregoing reasons, we think that this case should be affirmed.
You got a fee motion that's an offer of judgment. Is that a standard
Yes.
remand for determination of an entitlement amount situation? Is that what
Yes,
that
Your
is?
Honor.
And are there any issues, depending on how the outcome takes place here, that you need to have an opinion to preserve these issues that are at conflict, that are either pending or in the Florida Supreme Court?
I mean, frankly, we would absolutely prefer to have this case resolved without an
any
opinion.
of that.
Now,
Okay.
if you're going to rule against me on class membership, then I'm going to have a different view of that. But assuming you're affirming, Mr. Schlenther is 85 years old and in ill health, we can ill afford to wait for another level of review in this case.
I'm sorry. The style in this case that's come up to us is Reynolds versus Schlenther as PR and Harry Schlenther individually. I'm sort of assuming that style goes back to when this was a PI and not a wrongful death case, right?
Absolutely.
So-
The first case was first brought when Mrs. Schlenther was still with us.
Okay. Thank you very much. Mr. Katsas, can you hold it to about 3.5 minutes here, since we gave you so much to begin with?
The governing waiver principle is very simple and straightforward. The principle is that if the court chooses to instruct the jury that it will reduce for comparative fault, the court must follow through on that instruction. That's what Foreline says, that's what Hyatt says, because not to follow through on the instruction would be to mislead the jury. This case is actually one step worse than simply the court misleading the jury, because this is the jury being misled at the behest of the plaintiffs. The plaintiffs affirmatively supported the instruction that told the jury that the verdict would be reduced. Mr. Brannick says, why didn't we object? It's somehow our fault that that instruction was used. We didn't object because our legal position is that that is the correct standard. The parties agreed to the legal principle that the verdict would be reduced and agreed to present that principle to the jury. We are consistently defending that position on the merits and on waiver grounds. It is the plaintiffs who are trying to shift positions, who tell the jury we will reduce, and who post-verdict shift positions and say, oh, never mind, please don't reduce. On the prejudice point, the jury may not supposed to reverse engineer the damages amount with a view to comparative fault, but of course we all know, Judge Altenburn, as you suggested, juries make compromises, and in Foreline the court said juries may do that, and that's one of the reasons we don't want to mislead juries. But that isn't the only source of prejudice from these instructions. There are two further sources of prejudice. One is the plaintiffs make, in the closing argument, they say, look at us, we're accepting responsibility, they're not. Our position is moderate and reasonable, theirs is extreme, give us credit. It's a general invocation of credibility. Well, that partial concession is much less significant under what they now say is the legally correct view, which is there will be no reduction if they prevail on a concealment or conspiracy claim, than it is under the instruction that the jury was given, which is when they accept partial responsibility, that's going to have some consequences for them. And the third source of prejudice is the plaintiff, the question of the comparative fault allocation. This is a different comparison under our rule than under their rule. Under our rule, it was a proper argument for the plaintiffs to say, give us a small share of fault because the smoker was merely negligence, Reynolds engaged in a 50-year conspiracy. Perfectly good argument for them under our rule that the relevant comparison, it includes the conspiracy claim. It's not a proper argument under their view of the law, which is that the offsetting is only with respect to negligence and strict liability. So there's lots of prejudice from use of the instruction. With regard to precedent, Mr. Brannick mentioned the Hill case. The Hill case actually strongly supports our position. The Hill is a case in which the defendant sought the instruction, will reduce. Then the defendant, after the verdict, decided that the instruction was wrong and tried to attack the defendant's own proposed instruction, and the court said, of course you can't attack the very instruction that you proposed. That's the same principle we're invoking here. The plaintiffs were happy with an instruction that the court will reduce. They can't now post-verdict shift course and argue the opposite. That's what Hyatt says. If you disagree with us, you would have to certify a conflict with Hyatt. The only possible distinction we heard is of the complaint. If you read Hyatt, it actually doesn't rest on the complaint. There's a lot of text reporting the parties' arguments about the complaint, but the legal reasoning turns on the instruction and turns on the jury arguments, which are fully present in this case. Thank you very much.
Thank you. Next case is Keeler versus State of Florida.